let me welcome our two special guest presenters today. So we've got from our employment group, Teresa Thompson and Nora Olson-Bluestein. I always struggle with that.
It was great.
So Teresa and Nora are experts on social media let's try that again. They're experts on social media issues, but that's really just one area of the practice. You know, they spend most of their life dealing with employment issues, non-compete issues, and things like that. So whether it's HR advice or litigation, if you ever find yourself in a mess, you can feel free to reach out to them. I know if you get fights involving EPLI, sometimes you wind up having to use lawyers that are assigned by your insurance company, but they've been approved as counsel with a bunch of insurers, and so that's a possibility. But that's neither here nor there. Really, they're here to talk about Facebook, and I don't think that there's ever been a situation where a doctor maybe took a picture of a patient's private parts and put them up on the web or anything like that. I don't think that's ever happened, so this is purely hypothetical. And I will turn this over to them now so they can talk about this and other hypotheticals. The last parting word, you will get at the end of this in the chat box a link to an evaluation form. We'd appreciate it if you click on that link to tell us future topics and other feedback. So now I turn it over to Nora and Teresa. I think, Teresa, you're starting us off.
I am. So good afternoon, everybody. And unfortunately for all of you, it is we're not just talking about hypothetical situations here today, which is why we are still talking about social media in the healthcare realm. So we are talking today about a lot of things, and you might wonder, why are we talking about any of this? And the reason that we're still talking about this is because patients are using social media, and so doctors and clinics really need to be using social media as well. And because your employees are using social media, and employees' conduct on social media actually does affect the workplace. When Nora and I first started talking about social media, which seems like now ages and ages and ages ago, we used to be able to use hypotheticals because really we were talking about, wow, this new thing of social media, patients are going to be using it, employees are going to be using it, your managers are going to be using it, and we never really knew what impact that would have on the workplace. And for healthcare providers, it really is an important thing because employees can misuse social media, maybe without even intending to, and it has a really big impact on your liability, for example, for things like patient privacy, and it can really impact the morale in the workplace as well. So despite the fact that social media isn't a new thing anymore, we really do feel that it is an important reminder for employers to think about how social media is impacting the workplace. So what we're going to walk through today are a few of the things that we are regularly seeing in our employment practice, and those relate to the typical Facebook firings, the do's and don'ts of those. And yes, people are still getting fired for their comments on Facebook, and frankly, the conduct is getting worse than what we used to see. I think people are becoming more and more free with what they're doing online, and that is coming back to impact the workplace. We will talk about employee and patient privacy rights. What are your rights as an employer to monitor social media of employees? And what sort of patient issues are we seeing with regard to employees posting information on the internet? And this one is particularly frightening to me because instead of getting better, we see more and more conduct that is appalling, frankly, by employees and really should be addressed. And we'll give you some good practical tips on how to address that. We're going to talk about social media in hiring, what you can and can't do, what are some best practices when using social media in the hiring context. And then finally, we're going to talk a little bit about protecting your brand online. For those listeners who choose to take a look, sites like Glassdoor.com contain a lot of reviews on employers, compensation, what happens in the workplace, and we're getting a lot of questions about that. So we thought we'd give you a little insight into what you can and can't do with regard to negative posts online and how to impact and increase your positive online image.
All right, so I'm going to start out with Facebook firings. This is the big question that we get routinely from companies and healthcare employers. I can fire my employee for the post, right? They have learned of some sort of activity, usually because a coworker has printed out Facebook posts and brought them in to complain. The posts are really detrimental to the workplace, and the company wants to fire the employee. So we can do that, right? Well, my lawyerly answer is it depends. First, we've got to look at a few things before you just jump in and terminate somebody based on a Facebook post. One of the first things we want to look at is the post protected activity? Is there something about the nature of the post that makes it protected under state or federal law? And as a result, if you terminate the person based on the post, could they come after you and claim the termination was retaliatory and was unlawful? One of the big ones with social media cases is the National Labor Relations Act and Section 7. This one is interesting because I think the misconception for non-unionized workforces is they don't need to pay attention to the National Labor Relations Act. Well, that happens to not be true when we're dealing with Facebook firings, because this applies both to union and non-union workforces. What does Section 7 say? In a nutshell and in plain English, it says that employees have the right to discuss the terms and conditions of their employment. This is construed extremely broadly. What are terms and conditions? It's almost anything relating to the workplace. And it includes, which we're going to get into a bunch in a second, it includes criticizing your supervisor. So remember, as we go through this, even if you don't have union employees, this law and this issue really does matter for you. The National Labor Relations Act isn't the only law that we worry about when we're thinking about Facebook firings. We also need to look at whistleblower laws. So for example, does the state you're in, like Minnesota, have a whistleblower law that says that if an employee complains about a violation of law and you terminate them because of that, that person's a whistleblower and they can't be terminated for making a complaint like that. Similarly, is there something about the post that would be protected under state or federal civil rights laws? We've got privacy laws at issue as well. We even have the FMLA and ADA, and we've got an FMLA example that I'll go through in a couple minutes. So lots of different laws at play. All of this is just a reminder that before you terminate, you've got to think about whether a post is protected. So let's go through some examples. This first example is a National Labor Relations Act case, and this is actually the case that sort of got all of this going. It's the American Medical Response case. So in this case, we've got employees who are talking on Facebook, and they're criticizing their supervisor. And you can read the slides so I don't have to use the vulgar terms that are being used. But you have more than one employee engaging in this discussion, being critical of a supervisor. The employee was terminated for the post because, you know, from the employer's perspective, they don't want posts on Facebook where their organization and their supervisors, their management is being criticized. The employee brought an unfair labor practice charge, and the National Labor Relations Board found that this post was actually protected. The employee should not have been terminated. The analysis was that, like I mentioned a minute ago, under the National Labor Relations Act, employees have the right to criticize their supervisors. So the post was protected. This got a lot of employers up in arms. And it was just the start of a whole raft of National Labor Relations Act cases, and we'll go through a couple more. So here's one that is sort of the flip side of things, where a post is not protected. Here you have an employee who's talking about a consumer in a disability services provider organization and making really disparaging comments about the consumer. That employee was also terminated, brought an unfair labor practice charge, but here we got a different result than in the American Medical Response. What's the difference here? Well, first of all, there aren't more than one employee conversing on Facebook. Here we've got one employee who's out there posting. I believe in this case there were some friends that were responding, but they were not employees of Martin House. So that was a big distinguishing factor. Another reason the post isn't protected is there's really nothing in here that's relating to terms and conditions of employment. This disparaging comment about the consumer being called spooky, that's the consumer, that's not a supervisor. So we're not criticizing supervisors here. We're not talking about wages. We're not talking about breaks or things like that. So there's really nothing about terms and conditions of employment. I would say my takeaway from this one is the terms and conditions of employment piece is important, but just that really threshold issue of who is the employee talking to on Facebook. Are the people who are responding employees or not makes a really big difference.
And before Nora goes on, this is Teresa, you might be interested to know that because there were no other employees that the employee was talking to, the way that the employer received a copy of this is that a former client was the one that was Facebook friends with this particular employee, was upset about the comment on Facebook and then provided it to the employer.
That's a great point. Here with the SkinSmart dermatology case, we've got another example of where a post isn't protected. This is one where the employee is criticizing supervisors and in fact is using quite a bit of profanity there and is essentially sort of taunting the employer and saying, go ahead and fire me, make my day. When the employee brought an unfair labor practice charge based on her termination, the National Labor Relations Board found that this post wasn't protected because no coworkers joined in. So there again, we have that piece is really, really important. If a coworker had responded and said, like in American Medical Response, you know, chin up, I think was the phrase they used, that might have made the difference between a protected post and an unprotected post. So that's really key. I would also add, you know, employers get really upset about the profanity, which is completely understandable. And in here, the post wasn't protected, but there was a relatively recent case called Pier 60, which made a lot of headlines because the post was even worse than this, and the employee was criticizing the supervisor and family members and using the F word like crazy. And that post was found to be protected because that post was made in the context of union organizing activity, and the employee even threw in at the end of the post something like "vote yes for the union," and that sort of saved their neck. So while it would be nice if we would all be more respectful with our language on Facebook, you can get away with quite a lot. So my next example of a post that was not protected is an FMLA case. So I wanted to throw that in there since we've been talking a lot about the National Labor Relations Act. In this Lineberry versus Richard case, an employee was out on family medical leave and went on a fabulous vacation to Mexico and posted pictures of herself enjoying herself on the beach and drinking margaritas, things like that. The employer found out about these pictures and ended up terminating her. But what was really key here was that they didn't terminate her for going on the vacation while on FMLA leave. They terminated her because she lied about what was going on. She tried to cover up the fact that she had these Facebook pictures of herself, and she claimed that, oh no, I really was incapacitated and unable to work. I may have been in Mexico and drinking margaritas, but I was in a wheelchair at all times, etc., etc. And they were able to show through other evidence that that was not the case. And so she was not terminated for violating the terms of her FMLA, but for lying about it. So a good example of another way that different types of laws like the Family Medical Leave Act and Facebook can run into one another. So what are our practical takeaways? You know, employees are doing all kinds of crazy things on social media, and a lot of them do implicate the workforce. So how do we know when we can terminate or discipline and when we need to sort of let it slide? First of all, we have to look at, is the post protected in some way? When we're dealing with the National Labor Relations Act, here's some things that I want you to think about. First, is the employee a supervisor? Supervisors are not protected under the National Labor Relations Act. So if you're dealing with inappropriate Facebook comments by a supervisor, generally speaking, you don't even need to worry about the National Labor Relations Act. Another point is, does the post relate to terms and conditions of employment? Like we talked about, that's pretty broad, but that the post does need to relate to that or it wouldn't be protected. Another point is the employee Facebook friends with any coworkers, and are the coworkers responding? One side point on that note is the coworkers might be responding directly, but they might be a little more passive in doing things like liking a post. That may also be protected activity under the National Labor Relations Act. So think pretty broadly about how coworkers are involved. So for National Labor Relations Act, think about those things, but don't lose sight of the fact that the post might be protected under some other law. One quick example would be if the post could be construed as a complaint of discrimination based on race or gender, or any of those other protected classes, and you terminate the person for the post, that could be seen as retaliatory, so you need to be careful there. But after you think about whether a post is protected or not, let's say we don't think it's protected, I would encourage you to think about another question, which is, does the post really justify termination? There's so much noise and so much garbage on social media that you should at least sort of pause and think about whether you really need to terminate the person for the post or not. Sometimes you will, but sometimes you can just let things go, get a bit of a thick skin. It will be so far down the stream in hours that it may just not be worth it. But each case, I would say, is pretty unique, and we want to look at it on a case-by-case basis.
And one of the things before we move away from this, you might be thinking, wow, is everything on social media protected, so I can't terminate employees when they're doing something they shouldn't do? Well, one thing that you can do is you should be looking for whether they're using your confidential or trade secret information, if they're disclosing protected information, if they're disclosing information regarding patients, for example. If they are doing something that violates another policy, such as inappropriately using confidential or private information, those actions usually take it outside of the NLRA or any other kind of law that might protect their conduct. So if somebody is doing that, I really do encourage you to seek legal counsel and find out, is this something that we can do something about from a discipline or termination standpoint, but also what can we do to get that information taken down or removed because it shouldn't be there to begin with. So there are some other things to think about with some of these posts. All right, so we're going to move on now to employee privacy rights, and I'll talk about patient privacy rights in just a few minutes. So this is one of those situations where we get clients call and say, you know, I think that one of my employees violating our social media policy, and so I want to monitor his or her social media activity. Or we might get the question, like Nora's FMLA example she just walked through, I think an employee is violating our FMLA policy because I believe they're on vacation. Can't I look at their public social media sites to find out what they're up to and take disciplinary action? So I'm going to talk through a few of those things now. So the bottom line here is that public information really is fair game. Now I put that in parentheses because, of course, what you can do and what you should do are probably two different things. So while public information is fair game, should you be snooping around on social media to find out what your employees are doing? In general, I think the answer to that question is no. if you have a legitimate concern and you have some intelligence, whether from another employee, a manager, or somewhere else, that an employee is violating a policy or engaging in conduct that you feel violates your workplace policies, then you absolutely have the right and ability to look at public information. I might limit who has access to that information and who looks at that information, but nonetheless, public information is sort of fair game. They can't claim a violation of a privacy right anyway if you look at that public information. Now, private information is a different issue, and where many employers get in trouble here is when they are trying to access private chat rooms, private websites, private Facebook pages, and they're trying to gather information in that way. So we'll talk a little bit about that. And the final thing that you want to think about, and this goes specifically to monitoring an employee's use of social media or the internet while they're at work using your work equipment. The biggest question there that you need to think about and look at your social media policy, look at your electronic communications policy, is whether or not you've placed the employee on notice that monitoring may occur. And what does this mean? This means that there is something in your handbook or in a standalone policy that says the employee has no reasonable expectation of privacy when they are using your equipment or accessing any online source using their systems or their communications or their devices or whatever you as an employer issue to them. And look for that magic language, because it really is magic language. And if you don't have it, then seek some legal advice on how to make sure that those policies do contain the language necessary to place the employees on notice. So I'm going to walk through a couple of examples here. This first one is an example of gathering non-public information. And in this case, it is pretty egregious behavior, frankly. Let me give you just a little bit of background. In this particular case, there is an employee who resigns, returns her computer to the supervisor. The supervisor accesses the computer, notices that the employee left her personal email account up and running so that no password was necessary to be entered. And the supervisor took that as his authorization to go ahead and read 48,000 emails on this former employee's personal email account. And the employee found out that her supervisor had been accessing this personal email account and took issue with it. Surprise, surprise. She did not want her supervisor poking around on her personal email account. And legitimately, the supervisor had absolutely no reason to be poking around in the personal email account and couldn't come up with any sort of legitimate basis for doing so. So the employee sued for violation of the Federal Stored Communications Act and for invasion of privacy. And in this particular case, the case survived a motion to dismiss, which is a pretty big deal. And subsequently, the case was settled. So we don't know exactly what happened. But what we do know is that the manager and the employer were sued under these substantial federal acts and under a state invasion of privacy claim, and the employee got something out of it. And in this particular circumstance, what you really should be thinking about is how do you place your management, your IT professionals, et cetera, on notice that even if somebody leaves behind personal information on a computer, such as leaving their personal email account open, that is not authorization to access, and in fact, it can constitute a violation of federal and state law.
I think another thing to remind supervisors, managers, when you're doing training on this is, you know, there's something about social media that just makes things so easy. It's so easy to send out a tweet. It's so easy to get caught up in wasting time reading things on the internet. I think that is a good example here. You know, who has time to read 48,000 emails? But you can easily get sucked in. Maybe they were really juicy. But just because things are so easy doesn't mean you should do them. And we're going to have a few other examples of that too.
All right, so we've got another example here of non-public information, but the result was a little bit different. So in the Elling versus Monmouth Ocean Hospital case, we have an RN who is posting to a private Facebook wall. So we don't have a situation where the employer can simply go online, put in the employee's name, and access the Facebook page by themselves. And here, the RN is actually posting about an 88-year-old who opened fire at the DC Holocaust Museum. And the employee is objecting to the fact that the individual who opened fire survived. She blamed the DC paramedics and really sort of criticized the DC medics for doing their job. And you'll be surprised that an employee at the hospital saw this, was upset by it, and provided it to the employer. And the employer thought, wow, we can't really have our employees making posts like this, which criticize the very people who are the first responders coming to assist injured individuals and bringing them to our hospital. It sets a very bad tone for our organization, and we just can't condone this particular post. So they fired the RN, and the RN sued. And in this particular case, they found that there was no Stored Communications Act violation because the coworker voluntarily provided a copy of the post to management. And this part is key because if you have authorization to access a particular website, then there won't be a Stored Communications Act so long as you're not using it in a way that is somehow in violation of the Act. Normally, the violation is the unauthorized access of a private site. And in this case, because the employer wasn't trying to gain access to the private site and the coworker voluntarily came forward and provided it, there was no violation. And you might wonder, with all the posts that Nora was talking about, how most of these posts get in the hands of the employer so that they can look at it and decide, boy, do I want to fire this person over it? Well, the fact of the matter is your friends on Facebook are not really your friends. If they don't like what you're doing and they're one of your coworkers, they are going to provide them to the employer, and they'll print out a copy. They'll take screenshots of it. They'll take screenshots of all of the comments of it, and then they'll turn it into the employer saying, I want you to do something about this. And so one thing to think about here is to really think about who are your friends on Facebook, and should you be friends with other coworkers? Should you be friends with your subordinates, for example? Because in the end, if you do something on Facebook that they don't like and they think impacts the workplace, they could very well be the one printing it off and bringing it into HR. So what are our practical takeaways here? With regard to whether or not you can monitor somebody's activity in the workplace. And this really is meaning that you are asking your IT folks to affirmatively look at what your employees are doing while they're doing it or after the fact. So in that particular instance, if you've got something in place where you are engaging in monitoring, then just ensure that you've got the appropriate policy language that gives you the opportunity to do that. Now, I know that we have some folks from all around the country on the line here today. In Minnesota, we are a single-person consent state, meaning that you can monitor or record or otherwise it's the wiretapping law. So you can record somebody's conversation without their consent so long as you consent and you are participating in that conversation. And the same thing kind of applies to the monitoring analysis. So if you are in a two-party consent state, such as California, then you really need to jump through a few hoops to be able to ensure that when you are monitoring an employee in the workplace, that you are not violating the wiretap laws of that particular state. So when in doubt, please make sure that you're checking with legal counsel on your right to monitor and the impact of that based upon that one or two party consent, because violation of the wiretap statute is not something you want to add to the list of no-nos in your workplace. The second thing to really think about is to use publicly available information whenever possible. This means don't be going and asking your employees to give you access to a website or a chat room or a Facebook page that you wouldn't have otherwise had access to. The cases that are coming out here really come down hard on employers who coerce or otherwise ask employees to do something that they can't do. And that never comes out favorably for the employer. So if it is voluntarily provided to you and somebody walks into your office and gives it to you, that's fine. But if you're having to go down and track down employees to give you access to something, you know you shouldn't be doing that, and it can get you in trouble under some of these state and federal laws. We've also had questions about whether or not you can pose as somebody else. Can I create a fake Facebook account? Can I create a fake LinkedIn account to try to track and see what employees are doing online? And the answer is no, don't do that. And the final line is supervisors should really avoid friending supervisees. This should be obvious by now, but we see this all of the time, and it can lead to a lot of problems down the line. So I'm going to take you through patient privacy rights here too. I think all of you who are on the line know very well that patients have privacy rights and that your employees should not be posting anything about patients, residents, consumers online. None of those things should get anywhere close to being online, but nonetheless, they do. It shouldn't be photos and it shouldn't be information. We all very much know that sharing patient information is going to lead to legal liability under HIPAA or state privacy or medical laws as well. So when you're talking to your employees about their obligations to avoid doing this, make sure that they know that by doing so, they are violating state and federal law. Because sometimes it's enough to tell them that they're violating a specific law to get them to stop doing so. Unfortunately, there are a lot of employees that provide posts about their workplace and about patients without really even thinking about it. This particular example is pretty old. It's 2011, but we continue to use it because it is a physician at a Rhode Island hospital who wrote about her experiences in the ER in a particular day. She didn't use any names, but nonetheless, there was enough identifying information about the patients that she wrote about that the hospital and the Rhode Island Medical Board took issue with it. She was fired and lost her privileges. And so for those, if we've got any doctors on the line, this is a pretty big deal. And this was just somebody venting about the workplace. But it could have been avoided had somebody maybe talked about this with the doctor to ensure that she understood that this was a very bad idea. These are just a few examples of nursing staff and other medical staff engaging in conduct that they should not be engaging on in social media. So here we've got somebody posting pictures of a stabbing victim instead of treating that individual. We've got a student nurse posting a photo of a 3-year-old chemotherapy patient. We have a student nurse posting photos of herself with a human placenta, which is the one, at least of our examples, that is the most troublesome to me. And you really wonder why in the world are employees doing this. Well, we found a recent article, and I couldn't possibly go through them all, but it was at least, 5 pages long of Facebook posts or other social media posts where employees of long-term care facilities are posting pictures of not only medical information, but also of individuals who are vulnerable under the state's Vulnerable Adult Act. And so what it shows is that employees still don't understand that there is a need to protect this information. So what is our practical takeaway here? Make sure that your employees understand that they absolutely cannot discuss patients, post any sort of protected health information, including any photos, no matter what the purpose. and that they can't friend patients. That interaction creates too much legal liability and frankly causes a lot of bad press for the organization because it really shows that you're not demonstrating control over what your employees are doing. If your employees insist or the patients insist upon interacting, then make sure that it's on a professional networking and education site and not on personal social media. That's a little too much to go for. And providing specific examples of bad behavior is one of the best ways to get it through to employees that, hey, this isn't like going out for dinner with your friends and taking a picture of what you're eating. You absolutely can't just click and post. And that doesn't matter whether it's Facebook or Snapchat or Instagram or something else.
So my next topic is social media and hiring, but we've now got a nice little pile of questions here. So I thought it would be nice to break up our lecturing at all of you to answer some questions. So first question. And a bunch of these relate to the section on, what posts are protected and can you fire somebody for their post. So what if there's a combination of employees and non-employees responding to the post? That's a great question because that is something you find a lot. It can be a mixture. The post can still be protected as long as there's one other employee who's posting with the sort of original employee. So that would mean a total of at least 2 employees. Then those posts could be protected if you meet those other criteria. So just because there are some non-employees who are also posting really does not change the analysis. But great question. Our next question is, are you able to provide a copy of the slides after the session? Yes, absolutely. The slides I believe David Glazer told us that you'll all receive a link once the presentation is up and posted, and that will get you to, I think it's SlideShare, I could be wrong. You'll be able to see the slides and hear our lovely voices. Next question. For protected posts, are there different thoughts if the supervisor and or physician owner is friends with the employee and sees the conversation and may or may not be engaged in the conversation? So this one, if I'm interpreting the question correctly, I think what it's asking is, what if you are friends with subordinates on Facebook and you see the conversation happening that way versus a coworker prints something off and brings it to you? Aside from the issue of whether you should really be friends with the person, if you are, and that's sort of water under the bridge, and you see it that way, then yes, you can take action based on it. I would just caution you again, be careful about being friends because you're going to learn a lot of other information that you're not going to want to know and take action on. But in this case, that's okay.
And if I'm interpreting that one a little bit differently, if you're talking about from an NLRA standpoint, then if there's a supervisor or if there's a physician who is engaged in that discussion, so long as there are individuals engaged in the discussion, if the person who started it, who's engaging in the protected conduct, is not a supervisor or an owner, those are still protected even if you have a supervisor or owner involved.
And if neither one of us interpreted your question correctly, just submit it again and we'll try again. Our next question, can you discipline without firing initially? You absolutely can discipline, but that's the same analysis. So disciplining an employee based on a Facebook post should also only be taken if that post is not protected. Otherwise, you could still find yourself violating the National Labor Relations Act. Our next question, if an employee is initiating Facebook posts while working on paid time, even if it's protected, can they be disciplined for improper use of paid time? Great question. So if the employee is engaging in protected conduct but is doing it on working time and getting paid, well, first I would say, what does your social media policy say about whether employees have the right to use social media during work time? If it's clear that they do not and it needs to be during non-working time, you could consider disciplining based on that violation of your policy. I would say it's a little sticky, and you'd want to do it in a careful way to try to separate that issue from the protected post. Teresa, any thoughts on that one?
It would be better if there were some conduct that was being engaged in on social media that also involved non-protected posts. In that particular instance, there probably would be. So if the conduct that is being questioned is the use of social media during work time period, that would be your safest thing to do.
Our next question is on that Ailing versus Monmouth case that Teresa talked about. That's the DC Holocaust Museum post. And our listener noted that they thought that the nurse was probably just joking, and it was hyperbole or irony. You know, that is a great point, and I think you see that. I certainly see that in the news all the time in our election year this year with all of the tweeting and things going on in the campaigns. And I would say, just like in politics, in the employment situation, sarcasm on social media does not usually end well. It could very well be that she was just joking, but that does not come across in a clear way when it's written down like that. And I think if you're going to be sarcastic online, you have to be ready to take the consequences. A quick question about the 40,000 email case where they read on the employer's time. You know, I don't know that the case talked about that. I think the supervisor may even have been an owner, so it was less of an issue. But that is interesting. Hopefully, it was not during work time.
And that may have impacted the determination of whether or not the employer was ultimately liable for the supervisor's conduct, but it wouldn't change whether there was a violation of the Stored Communications Act.
Right. I'm going to pose this next question to Teresa. How do you advise healthcare employees who refer their friend to a provider they work for? The friendship was there first. How do they handle this?
Refer a Facebook friend? Is that how you're interpreting that one?
Well, since we're dealing with social media, I would say yes.
Yeah, okay. Well, I think in this particular instance that if somebody believes that your organization is such that she would refer a friend, whether on social media or otherwise, to your clinic or your hospital, I think that's perfectly acceptable. I might question whether there's a conflict of interest to have that person providing care to that person if they come in, and that should be addressed up front with the patient if you learn that that's how they came to seek treatment. And I would hopefully ensure that that employee is not disclosing or discussing the medical condition online with this particular potential patient.
So the next question, last in my pile for now, and then Teresa's got just one, then we'll turn back to the rest of our slides. This is a good one, Teresa. So, protected or not, RN posted that patient, no name given, was choking on oxygen tubing. That the RN did not chart this, which would be his or her responsibility with something of this magnitude, nor did he or she report to the unit coordinator. This was just posted on Facebook. So again, the post doesn't reveal the patient's name, but does say that the patient was choking on oxygen tubing, and the RN didn't chart it or report it.
Nora's looking at me. So I think my feeling on this one is twofold. One, there would be a question about whether there was sufficient identifying information to have this be a HIPAA violation, and I think that might be questionable depending on whether or not you could tell who this RN was working for by their online Facebook page. The second thing would be, how did you get the information? Did an employee bring it in and say, hey, we just saw this, and then you looked at their charting and noticed that it wasn't charted? And I think in that particular instance, that would be a discipline issue, and certainly one from a performance standpoint to say, hey, we just learned about this. Number one, this is potentially a HIPAA violation, and number two, because you failed to chart this, we need to document that and ensure that you understand what your charting obligations are. And I don't see any issue with doing either of those things.
An interesting kind of twist on this would be, what if one employee posted that a coworker RN didn't chart something, and then that employee who made the report got terminated? Could they then claim that they were the whistleblower?
Maybe.
Yeah.
Yeah. Because charting is something that is required by law and certainly required before you get payment, so it could implicate a violation of a law.
Really great questions. Teresa, you want to do your
This is
question?
this is another one, and then we're going to have to move on here quickly. If a supervisor is already friends with subordinates in social media, should the employer ask supervisors to unfriend those subordinates? We do get this question all the time, and I don't think that there's a really straightforward answer, to tell you the truth. I think the best practice is to have your social media policy in place and then to have it apply going forward so that your supervisors are not friending their subordinates going forward. I think that it's harder to go through and say, supervisors, you need to unfriend your subordinates, because that can in the end cause some maybe some bad feelings within the workplace. However, if you implement a new policy, or if you go through some social media training and you make it clear that it is the policy of the organization not to have supervisors friends with their subordinates, then I think it gives you an opportunity for those supervisors to unfriend everybody without sort of the bad feelings.
And I've advised employers on this too, and sometimes I say, you know, maybe you can have HR be the bad cop and enforce the policy, and then the supervisors can explain when unfriending their subordinates that it's sort of, you know, it's not me, it's HR. Just like sometimes we as lawyers get to play the bad cop to help give the HR folks cover. But I think if you can have, there are ways to have a reasonable discussion, somewhat reasonable discussion about we're unfriending somebody not because we don't want to be friends with you and have that rapport, but just because there are business reasons that we need to keep it on a more professional level.
Yeah. Although you have to be a little careful then too, because then the employer's the bad guy. So
yeah, it's a hard one.
It is.
All right, let's turn to social media and hiring. We get this question a lot too. Similar to Facebook firings, but here it's sort of Facebook non-hirings. I can decide not to hire someone based on what I find on social media, right? Well, again, yes, maybe, but let's talk about what might be protected and what might not be protected. So if you're using social media to screen job applicants, you need to be aware that there are a bunch of state and federal laws that might be implicated. Again, when we're dealing with employment law, civil rights laws are a big piece of the equation. We also need to talk about the Fair Credit Reporting Act, which we will cover in a slide or two. There are state equivalents of that as well. And then there are also state laws on things like lawful consumable products, which we'll talk about, and social media password laws. So a whole bunch of different considerations you need to take into account. On the civil rights angle, when you're screening a job applicant, what we worry about is that you're learning protected class information. You're learning a whole lot of personal information, demographic information that you wouldn't otherwise know. You're in fact potentially learning way more than you would even when somebody comes in to interview, because when they come in for an interview you may see what they look like, but hopefully you're well enough trained and your hiring managers are trained not to ask those questions that you're not supposed to ask in interviews. But on social media, it's unfiltered, so you have the potential to learn all kinds of things. And then if you don't hire somebody, there is a risk that they turn around and claim you didn't hire me because of this information that you learned on social media. You also need to worry about the Fair Credit Reporting Act. So that law, companies often think, well, we're not talking about credit here, so I don't need to worry about it. But this comes into play in any kind of background check, social media check, when you're paying a third party to do the check for you. So a real common example is a sort of traditional criminal background check that you have a background check company do, like Verified Credentials or HireRight. Those are covered by the Fair Credit Reporting Act that puts obligations on the Consumer Reporting Agency as well as the employer. Social media screening of applicants could also implicate the Fair Credit Reporting Act if you're paying a third party to do that check. There's a whole niche industry of companies who will do social media background checks for you, and the larger background check companies may also be getting into that. What's interesting here, I've noted this company, Social Intelligence Corporation. They were interviewed by the New York Times a couple years ago. They're an interesting company because what they will help you do then is they'll do the social media background check, but they'll screen out the things you're not supposed to know. So they'll screen out that demographic information. They'll actually, if there's pictures of people, they'll block out all of the pieces of the picture that would show a person's gender, a person's race, things like that. They will screen out other types of information that's protected and then give you the rest, both positive and negative. So, but they are covered by the Fair Credit Reporting Act, and you would be too if you were working with them because you're paying them to gather the information. Lawful consumable products laws, a lot of states have these, including Minnesota. In plain English, this protects employees or applicants from being not hired because they were doing something off duty that's lawful. The classic examples are smoking and using alcohol if you're, if you're of legal age. So in most cases, if an over 21, somebody who's over age 21, there's a picture of them drinking. You can't not hire them because you don't like the fact that they drink alcohol, because it's legal for them to drink alcohol. So keep those state laws in mind. And then social media password laws. This has been a big trend over the last maybe 3 years. State after state is passing these laws. And what they say in varying degrees is you cannot require applicants or employees to give you their social media login information. So this is trying to get access to real-time social media information. A phrase that you often hear is that relates to these laws is they're trying to prevent shoulder surfing. So what was happening was employers were bringing people in for interviews and having them log into their social media accounts so that the hiring manager could get an unfiltered view of what's going on here. Really bad idea, even if it's not banned by state law. Way too much information that you do not and should not know. So shoulder surfing is a bad idea, and it could actually be illegal under state law. So what are our practical takeaways when you're talking about using social media and hiring? As with a lot of things, we want you to have a strategy that's consistent and thoughtful. Have a plan. Don't just run out there and do this willy-nilly. Think about these things. Who's doing the searching? Are you going to outsource it to a third party and then make sure you're complying with the Fair Credit Reporting Act? Or are you going to do it internally? If you're doing it internally, who's doing it? Can we screen that person off from the hiring manager so that that person can be trained, just like Social Intelligence Corporation, to just pass on the non-protected information? What are you looking for? Look for both positive and negative. We focus a lot on the negative, but there's a lot of positive information you can find on social media that may actually be job related. Big point there is look for job related information, not just sort of piquing your curiosity. Think about where and how are you searching. What sites are you looking at? Be consistent and try to look at the same types of sites for each applicant. And when are you searching? Where in the hiring process are you doing this? Are you waiting to post offer phase so that you're only doing the searches on a smaller pool of people to help mitigate how many potential claims you might face, or are you doing it really early on? If you're doing it really early on, why are you doing it really early on? What's your sort of business justification for that? You have a fair amount of leeway in what your plan is, but you should be able to articulate why you're doing things the way you're doing them and what the business reasons are.
So I'm going to answer a quick question here related to drinking. Can an employee be disciplined if the employee is on a company paid trip for a convention? So assuming that the employer finds out that the employee is drinking while on this company paid trip, I think the question there is whether or not the conduct violates one of your company's policy about drinking while quote unquote on duty. There is a difference between on duty and off duty. I think this would be a gray area because whether you're paying for it or not, there's a lot of downtime at a convention. It could very well be off duty. I would check on the circumstances surrounding that before taking disciplinary action on that one. All right. So we're going to move on to protecting your brand online, and this is our last topic here today. And here is the typical example. A former employee has anonymously posted false and misleading information about the facility or the clinic on Glassdoor.com and on Yelp, and let's just add in on Google. What can we do? Should we respond? Will the websites take down the post?
I was helping somebody with a Glassdoor question just this morning.
Yes. So the bottom line is that you have the right to respond to a negative online post if you choose to do that. And this is a little bit like responding to kind of bad posts by employees. And we ask clients all the time to step back and ask the few questions. Number one, does the post contain any HIPAA protected information or any other sensitive or confidential information? You want to know that because if it does, you absolutely need to take some action because you have an obligation to get that information removed. And the websites are going to remove that information if you can show that it is protected information that the employee is wrongfully sharing online. And you'll have good luck with the websites when you're seeking to have that information removed. Number two, this is where the question becomes, is the post really believable and will it hurt your company? Do you have an employee who is just out there ranting on all of the review sites about how awful your organization is without really saying anything at all? And does that just make the person look crazy versus legitimate? And so you really want to know whether or not it's a believable post. But if you think it's believable and it contains false information about your company or perhaps contains information specifically about an employee within your organization and it seems targeted at that person without a legitimate basis, then again, there might be a basis for having that removed. All of that said, there are a lot of reviews, no matter how negative, that the sites just won't take down so long as they think they are legitimate. And I'm going to talk through Glassdoor's kind of guidelines on that just to give you a little insight. But remember, if you find that there is false information posted, defamation claims are really hard to win. So we have clients call and say, I want to do something about this because this person is saying all this bad stuff about me and it's false and it's injuring my reputation and I want to do something about it. Well, I'm going to take you through an example of why you might want to step back and see whether or not legal action is the way to go. In this Dietz versus Perez case, we actually had defamation lawsuits filed against one another. So Dietz filed the defamation lawsuit against the customer, Perez, for online statements, and then Perez filed counterclaims against Dietz, claiming that Dietz's online responses were defamatory. But the jury, in the end, the case went all the way to the jury. So think about the amount of money that it took to get to the jury. Ruled that both parties had defamed the other, but then awarded zero, nothing to either of the parties. So they went all the way to a jury trial and got nothing out of it. Now, it's pretty significant that there was a defamation finding at all, but here, what it shows is that you might not ultimately get what you want from a defamation lawsuit. So think hard about whether that's the way you want to go. With regard to Glassdoor, because this is what we're seeing pretty commonly with clients these days, they're calling and saying, hey, there's this terrible review. What you want to do is take a look at the review guidelines on Glassdoor. You'll be able to find them by going to their homepage and looking through some of their Q&As. But Glassdoor really does provide guidelines to those people who are posting reviews online, and it tries to tell you what you should do and what Glassdoor is looking for with regard to reviews. And if you look through this and say, hey, the employee or former employee didn't follow the guidelines, then you might have a basis to submit a complaint to Glassdoor. So this gets down to the issue of responding. You can respond without the employee even knowing it. So you can reach out to Glassdoor and you can find out, you can ask them, hey, this is not true. This is something directly relating to confidential information. It is maybe a rant against the CEO and contains very private personal information about the CEO. Those sorts of things, Glassdoor is actually going to take action and probably take them down. Now, I have to say that if you're going to go to Google, you might not have any luck whatsoever unless you have some sort of court order. So what are our takeaways here? Number one, determine whether a response is really warranted, meaning will the post truly hurt your business? If so, you can write a neutral response. You can ask the review site to remove the post, or you can seek legal counsel about the viability of a defamation claim. But you do have options there, and I recommend that you figure out a consistent approach to take and definitely monitor what's being said about you. But the other thing that you can do is you can positively increase your company's online brand. Create a Google Plus account, maintain positive Facebook and LinkedIn pages, try to get consumers and clients and employees saying good things about your company online, because that is the best way to combat negative reviews, is to have people saying positive things about you online. And it might be a more proactive way for you to be able to respond to this type of problem. And don't prevent, Nora talked to you about all of the bad things that can happen if you try to prevent non-supervisory employees from posting online. Don't try to prevent these bad things being said about you. Try to get around those bad things in a lawful manner so that you don't end up with an NLRB complaint on your desk. So that's all you've got. If you've got questions afterwards, you are free to reach out to Nora or to me. We were happy to be here today and hope you took something away from it. Thank you.